serious friction
Oh, yeah.
between new spouse and
Oh,
old
yeah.
children on both sides, both feeling like they're entitled to have the things that were the possessions of their spouse or their parent.
I'm Elise Myers. I'm an attorney at Cohen Pollock, Merlin Turner. Been here for about a year now. I do estate planning, probate administration, and I do some estate litigation here as well.
I'm Claire Mattson. I'm an attorney at Cohen Pollock, Merlin Turner. I practice in the areas of estate planning, probate, estate, and trust administration. So in working with clients and handling probate and estate administration, what are some of the things that you're seeing lately that are presenting the biggest situations that your clients are facing?
So I think, I do a lot of probate work, and in doing a lot of probate work, something that's been coming up for my clients a lot recently is I've been seeing a lot of creditor issues, a lot of creditors coming into my estates, and what happens when the creditors are an issue is we just don't have a lot of estate planning. That's how my creditors are becoming a problem. We don't have wills, or we do have wills, and it's just not well planned. So my creditors are coming in, and they're really getting into my estates before my heirs or my beneficiaries can take the estate, and it's becoming a problem for my clients. What about you? What problems have you been seeing?
Well, I was going to actually follow up on that. Do you think that that the clients are not understanding how the relationship with the creditors works, or is there a misunderstanding with how creditors have to be dealt with in the context of probate and estate administration?
It's a double-edged sword. There's a misunderstanding, and like I said before, there's just a lack of planning in some of these. So those creditors get paid out before anybody else does. So if there's no planning, in some cases, creditors are going first before those heirs get in there. Or if there's lack of titling or lack of probate planning in the first place, maybe somebody made a will and just didn't plan for those probate items, or didn't plan for that in their documents, or didn't work with an attorney to do their documents. They didn't realize that the creditors were going to come in as their first line and get it before it goes to those beneficiaries that they thought and hoped that they had planned for.
I've seen situations where clients have tried to avoid having assets pass through probate, and so one of the things that they'll do is that they will choose to name beneficiaries on all of their accounts, or they will name transfer on death or pay on death beneficiaries on accounts or title accounts jointly in an effort to avoid probate. And in doing so, sometimes they leave their main asset in the estate, their home, but they've deprived the estate of all the liquidity that their estate could use to pay expenses. And unfortunately, you as the deceased person are gone, but your debts remain. Your creditors, your credit card companies, the expenses related with the maintenance of your house, even income taxes, all those still have to be paid. But if there's no cash left in the estate to use, your family can be in an awkward position of having to kick in money to help take care of things before anything can be distributed. The house can be sold, accounts can be divided. It becomes a very tricky situation for a lot of estates that could easily be avoided by proper planning in advance.
That's right. So what would you suggest? So that's what I've been seeing a lot more of that recently. That's been coming up a lot for me. So when you plan, what would you suggest for planning then?
Well, suggesting for planning is using properly constructed documents that have been prepared by an attorney, reviewed or drafted by an attorney in the estate where you live, and making sure there's an understanding of how the assets pass under the will and outside of the will in a use of beneficiaries, joint ownership, and the planning under a will, or using a revocable trust as a stand-in for a will, essentially directing the distribution of the assets upon your passing. And hopefully in doing that, you can maybe avoid some of the time delay of having to probate a will. It's a very popular topic in estate planning. A lot of people are very concerned about how assets are going to flow without having to go to the probate court or having their family have to deal with the probate court. And using a revocable trust is a really great way to do that. And as long as you've talked openly with your advisors about how your assets are titled and your goals and planning, the right advisor can help you make sure that those assets are there to pay any final remaining debts that you might have, and then distribute them efficiently to your family.
I could not agree more that those planning techniques would solution a lot of these creditor problems that have created a lot of woes that I've been seeing recently in these estates. And to that effect, a great financial advisor, I think you might have talked to Tesh about this earlier, as a matter of fact, a good financial advisor could help with some of these liquidity issues by some products like life insurance too, when you maybe have assets here or there to maybe bridge the gap in some instances when you maybe have younger clients and things like that, because I've had some of those.
Using, again, the right planning techniques, making sure you have assets titled correctly, and life insurance is a great tool to build some liquidity if you need it for a family, but making sure that you've included all of your advisors in on planning is a way to make sure that happens. I've seen a lot of issues recently too with the loss or misplacement of original documents.
Oh.
And even beyond that, sometimes one of the issues isn't the originals, we don't even have copies. And so with a will, you can probate a copy. It's easier to probate an original, but you can probate a copy in most circumstances. But if you've lost original trust documents and there are no copies of trust documents, the only solution there for you is to go to the Superior Court. And that becomes a very time-consuming, costly process that could have been so easily avoided by just maintaining the documents in some secure location.
And telling somebody, and telling a friend, a family member, one of your fiduciaries that you name, your executor or your trustee, as the case may be, where you've placed them or placed those copies. I know a lot of people get very close to the vest about where they are. I've also seen quite a few that assume that their attorneys have kept copies. And that's not all, or not copies, have kept the original, but a lot of clients like to take their originals, I know, and then we sometimes have a copy, and sometimes they want to take all the copies with them. So I think it's a worthy endeavor to, if you've done estate planning, to go ahead and look while you're still here and confirm where those are. I know a lot of us make assumptions that, I think that so-and-so has it, and that sometimes is not the case.
Oftentimes we run into situations in probate and on the estate planning side where people are really trying to make sure that things are planned properly for the division of assets between second spouses or maybe even third spouses and children from prior marriages. But when they don't is when we really have problems on the estate administration side. And I always advise clients in those types of situations that they need to make adequate plans for what's going to happen after they're gone and their new spouse is living in the house and they've built a life together and they've acquired assets together. But there's children from prior marriages, perhaps on both sides, that also have expectations
adults
about
usually
where mom or dad's things are going to go. And that can lead to some serious friction between new spouse and old children on both sides, both feeling like they're entitled to have the things that were the possessions of their spouse or their parent. And so making plans in advance for how long does someone get to live in the house and what are their rights to live in the shared home, and what happens with the assets that weren't even financial assets but stuff, the vase, the violin, the art, the jewelry, the mixing bowls, the simple things in the house that may or may not even have any real dollar value, but they have emotional and sentimental value. Those can sometimes be a real hot button topic. And again, planning for that in advance is what makes that problem not always go away, but be dealt with in a more expeditious way and with less hurt feelings. And managing those expectations in advance can go a long way.
It does really help. It really helps.
What about you? I know with your probate practice, you see a lot of situations where people have done estate planning and they're in probate, but also situations where they've not done estate planning and they're on the other side of the probate court spectrum in administration and custodial and guardianship situations.
So, and I have little kids, so I see little kids come through. So when you don't, I have some where we have little kids in a probate situation where a parent has died and we have young children with a deceased parent, and it's all around it's a sad situation. We have a deceased parent that maybe had some assets, and we go through the probate, and the probate itself it's fine. But what happens on the other side of the probate, is you have minor children. The spouse gets if, let's say a third, if there was more than one child, maybe they get a third, and then the children get their portions of the estate, and it's held in conservatorship for the child, or the children for each child. And the probate court views that as we are conserving those assets for those children until they become 18 years old. So that means that the surviving parent, until those children are 18, are filing inventories and annual returns year after year after year on behalf of those children. They have to file a bond. They're just back every single year reporting to the court what they're doing with the deceased spouse money, because that's what came through the court for them. And the judge is putting oversight. They have to ask to spend the money to raise those children. And here's the scary part, and I tend to use my own daughter in an example here because she's a good example for it. So if it happened to me, when my daughter would turn 18, the law says you would have to hand over the money to her. She turns 18, right, which would be right at the top of her senior year of high school. Can you imagine what she would do with that? She'd spend it immediately. So in those situations, though, the surviving parent has to report to the court, report. And those parents just want the court to go away until the child turns 18. And then they have to turn over all the money. And that's really when they want the court to stay. And that's the end of it. It's just the worst possible situation. In the estate planning, you could put that, whether it's a revocable trust that you create during life, or even a trust under will that it would flow into. A trust could mitigate all of those things, where you wouldn't be in that conservatorship, where you wouldn't, unless you want to turn it over. I mean, wouldn't want to turn it over to my senior in high school, but unless you want to do that, you wouldn't have to turn it over to your 18-year-old.
And do you find that people are completely taken by surprise to find out that the assets are split between the spouse
Yes.
and the children? Most people just assume, when I die, everything will go to my spouse.
Everybody's surprised.
But that is not the case in Georgia, and it's not in the case in most states.
It is not the case, and they are all always surprised.
So easily avoidable by having even the simplest of estate planning.
And one step further, they're surprised by the view of the court that we are the view being that we are conserving for this child's adulthood. Like, it is not viewed as this money is to raise these children either. It is viewed as their adulthood money.
And that reporting requirement to the probate court through the course of the guardianship and the conservatorship is serious. It's real, and it's
real,
annual.
And it's real, it is annual. And it's not to say that judges won't allow you to, it's called encroach, to go in and take money to raise the child. But again, like the baseline view is that it's the child's money for when they're an adult, and it is not the child's responsibility to raise themselves. So it's just, that's where your baseline view is. So you can overcome that. You can get there, but you hear the difficulty, though? Do you hear the difficulty that I'm saying?
And all of which could have been avoided.
All of that could have been avoided.
That's the hard message to deliver is, this is where we are, but we didn't have to be here. So we could have made this easier with proper planning.
And so you go from a sad situation to just one of the most irritating things that you could be in.